Good afternoon, everyone.
Afternoon.
Okay, not sure how many individuals are on the phone. However, I generally will talk about, so today's training was supposed to be chapter projects and HG&A. However, I switched that for next week's training because there are specific questions on the HG&A funds and how to properly use those funds, as well as how to create chapter projects within Title 26 and how you can, so basically the training for next week is about trying to figure out how to create different committees to allow the chapter to move forward on different projects. And it's going to be, it'll talk a little bit about the law, but then it's also going to be a how-to model of creating committees and using funds to create community wellness projects. That's for next week's training. This week, however, I will be talking about the Navajo Nation Privacy Act. So how many of you know what the Navajo Nation Privacy Act is?
Yeah.
Do you know what the Navajo Nation Privacy Act is?
Yes.
Okay. Do you know also when it was established? So I just kind of want to get a general sense of where your knowledge base is, so that way I can also incorporate different things along the process of my talking about the Navajo Nation Privacy Act. Does the chapter that you work for have a policy in place?
I don't think very many of them do.
Okay, so I'm just going to get started on talking about the Navajo Nation Privacy Act and what it is. And also, before I start this presentation, I want to let you all know that this presentation is intended for general information purposes only and should not be considered legal advice or opinion on any specific facts or circumstance. So beginning with the first slide here, the Navajo Nation Privacy Act. So the intent of the Navajo Nation Privacy Act is to provide the public access to records and information while protecting privacy rights of individuals and entities. So the Navajo Nation Privacy Act is important for several reasons. This is important because chapters sometimes will have different projects that you're working on. For example, whenever you're collecting data. So, for example, there are some chapters who are collecting data for CLEP-C, and some of the data that they're requesting for involves maybe a census number or a date of birth. So my interpretation of that would be a census number is very similar to a social security number. So that kind of information would be protected and private information from that individual. So, and then also date of birth, if it identifies the person and who it was assigned to, then that would be protected information also. And also any medical records, like for example, if some of your chapters have different policies and procedures that involve requesting for medical information from an individual, that would also be considered private information. So the reason I'm talking about this is because there are some chapters who are wanting to get data management or who are trying to get data from community members. And so community members will provide chapters certain information. For example, if there was like a sheet that you all are using to collect information from the chapter members, maybe you're trying to collect information for housing projects and you need the census number, the date of birth of somebody and also the name, their address. So with all of that information, what the chapter is going to do with that information is important. So if someone comes over to the chapter and requests for this data, there may be some problems because, and it depends on which entity is requesting for that information. So I'll get a little bit into that a little bit later. But for example, if a chapter has, so I'm going to talk about a scenario in which a chapter is collecting data of a community member, and the community member provides their social security number or their census number and their date of birth or any kind of medical information, and an outside party, like for example, maybe like the BIA or maybe Indian Health Services or another federal entity is requesting for that information. So ordinarily, that information that's being requested, if there is information that's protected, as I stated, like the census number, as well as the date of birth and any medical information, that information should not be disclosed to those outside entities. The reason I say that is because some of that information is considered private and protected. However, if the requesting party is a Navajo Nation entity, then the rules may change a little bit. So I'll talk a little bit more about three very important areas that describe and define what is a private record as opposed to a public record. And so in that case that I was just in the scenario which I was presenting earlier, chapters should really be cautious in releasing information to entities outside of the chapter, as well as entities that are outside of the Navajo Nation. So the reason I say that is because there should be these provisions and a privacy policy in place of the chapter. Even if the chapter does have a privacy policy in place at the chapter, you may want to have your chapter policy be reviewed by DOJ to make sure that the policy does not prohibit or restrict access to public information. So sometimes there could be some individuals who are restricting information for like public information. That would not be authorized under the Privacy Act. Because the idea of the Navajo Nation Privacy Act is to provide public access to records and information, but also protecting the privacy rights of the individuals and entities. So why am I talking about this? I'm talking about this because there could be a potential for lawsuits. If, for example, a chapter released information that it wasn't supposed to, that was considered private, to an individual outside of the Navajo Nation, and that information was released, and then someone found out about it, and then the person who was harmed by that could sue the chapter. So this is the reason why I'm talking about it, and this is why it's important. So at the end of the PowerPoint presentation, you will answer the following questions. So what is the history of the Navajo Nation Privacy Act? What is the Navajo Nation Privacy Act? To whom does the Navajo Nation Privacy Act apply, and why is it necessary for chapters to protect private information? And how does the Navajo Nation Privacy Act apply to chapters? I'm going to talk generally about the history of the Navajo Nation Privacy Act. So on April 23rd, 1999, the Navajo Nation Council passed the Navajo Nation Privacy Act. And those amendments were made to Title II, and it's under Title II, NNC Section 81. And on May 4th, 1999, the Navajo Nation President signed the resolution CAP 4899. I have a typo there, so I'll take out that extra 99. So on that day, Navajo Nation President signed the Privacy Act into law. And on August 24 of 2006, there was a Supreme Court case that talked about the release of public information. And in that case, there is, I'll talk a little bit more about the summary of that, but I just wanted to give you an overview of the history of the Navajo Nation Privacy Act. Also, on November 19 of 2008, the Attorney General issued an advisory opinion talking that specifically allows governmental entities to share information among each other. Also, that kind of depends on the case-by-case analysis also. So, but generally, Navajo Nation entities should be allowed to share information with one another. Granted that the Navajo Nation entity requesting the information does not use it for personal use, but uses it for a legitimate government interest. The history summary: in 2008, the Attorney General, in 2008, the Attorney General opinion states that the Navajo Nation government entity must release records to another Navajo Nation entity unless another Navajo Nation law or federal regulation restricts access. For example, the Navajo Nation Laborers Commission restricts what documents can be released. Also, federal law prohibits release of medical or other records even to the Navajo Nation governmental entities. In 2006, the Navajo Nation Supreme Court decision decided that the Navajo Nation Labor Commission should allow the public to access its records and its hearings, but only if the record does not contain any protected information or is not prohibited from any of its own rules to govern its proceedings. But depending on the type of record, the confidential nature of the record, the Navajo Nation Labor Commission may restrict certain records. And then in 1999, the Navajo Nation, so under the resolution CAP 4899 amending Title II NNC 81, the Navajo Nation Council adopted the Privacy Act to allow the public to access records and information relating to the operation of the Navajo Nation. What is the Privacy Act? The Privacy Act aims to balance two values, to allow unfettered access to government information, and two, protect privacy of individuals who are affected by the government. And that comes straight out of the Navajo Nation Supreme Court opinion. The Privacy Act protects private records from being disclosed to the public. So under the Privacy Act, the record means all books, letters, documents, papers, maps, plans, photographs, films, etc., that are in the possession of the Navajo Nation government. And so as a chapter, you are considered under the Navajo Nation government because Navajo Nation Council delegated to chapters the authority to govern local matters. However, Navajo Nation chapters are still part of the Navajo Nation government. And also, I wrote that in Title II, NNC 83E, you can look at the entire definition for what qualifies as a record. Moreover, there are two categories of records. There's a protected record, which contains data on persons or governmental entities that is private. And a public record is any record not private or otherwise protected and not exempt from disclosure by Title II. So some of this information may seem a little confusing. If it is, you can certainly send me your questions after this PowerPoint training, and I will attempt to answer them accordingly. To whom does the Navajo Nation Privacy Act apply? The Act applies to the Navajo Nation government, to all Navajo Nation government entities and divisions. Why is it necessary for chapters to protect private information? To ensure that chapters are not disclosing private information and to protect the chapter from potential lawsuits. How does the Navajo Nation Privacy Act apply to chapters? Chapters should have an internal policy to allow access to public records. Chapter privacy policy should comply with all Navajo Nation laws and policies, and chapters should protect private records from public disclosure. In conclusion, the intent of the Privacy Act provides public access to information while also protecting confidential information in the possession of the Navajo Nation government. As I stated before, that as I stated before, the Privacy Act really, if, for example, there is a government official, like, for example, if there is a council delegate who went to the chapter requesting for information that the chapter has in its possession. Now, ordinarily, depending on the type of record, what one would do is figure out whether or not the information is protected and whether or not the information is public. But also, because the the council delegate or the chapter official requesting for the information is using that information for a legitimate governmental purpose, I generally would think that it would be okay to allow access to that information. However, the chapter should have an internal form that the council delegate or the chapter official or any other Navajo Nation entity who is requesting for that information fill out a form and then provide the purpose of the form. So the reason or the purpose of the records that's being requested. So the reason that is important is because there is, under the Attorney General opinion, that states that chapter officials or individuals or entities requesting for governmental records must have a legitimate purpose for that document or record. If the chapter official or the council delegate or any other Navajo Nation individual from an entity or the government is requesting for that information and is using it for an improper purpose, which is for personal use, then that is sanctionable under the Navajo Nation Navajo Nation Prosecutor's Office. It could lead to criminal sanctions and also civil sanctions as well, which is why it's important for chapters also to make sure that when you're releasing information, that you're not releasing any private information to outside entities. But if you're releasing information to individuals who work with the Navajo Nation government and is requesting for that information, generally it should be okay. However, it depends on whether or not the information being released also has like private information associated with the information being requested. So that is it for the Privacy Act, and it's very general. The reason the Privacy Act training is very general is because it requires a case-by-case analysis. And depending on the facts of the case, if there's something that, if there are individuals who are requesting for information and you're unsure as to whether or not there's protected information or private information in that data, and you don't know whether or not to release the information, you can always contact DOJ, you can contact me. My information is here, it's in Gilmore at Navajo Nation Department of Justice .org. You can also call my office at 928-871-6932 or 6933. So moving on to, before I move on, does anyone have any questions? No?
No, I don't have any questions.
Okay.
I think we understand it.
Okay. And so does the chapter require that everyone who requests for information fill out a request form?
Paulina Two Gray Hills chapter requires it. You have to fill out a form even for if you're requesting something for yourself to get personal information and prove that it wasn't just given to anybody in case you lose your paperwork. Then we have proof that the person picked it up themselves, their own personal information.
Okay. Do you all understand the reason why the Privacy Act is in place?
Yes.
Can you provide me a summary of why?
To prevent identity, probably some in case the identity theft or misuse of information for other people that it doesn't belong to.
Yes, but it's also to protect confidentiality. Because as a government entity, while we do want the public to be involved and have access to government records on the operation of the Navajo Nation, there are certain information that should not be released. So shouldn't be released, and because of that, we want to make sure that the chapter is. So my job really is to try to protect chapters, or actually my job is to protect chapters from being sued, which is why I give these legal trainings and put PowerPoints together to make sure that chapters are not or are complying with Navajo Nation laws. So that way there are less lawsuits being filed against a chapter for doing things improperly. And also, recently, there have been a number of different things. For example, community members who state that chapters are releasing information, and they think it's improper that the chapters are releasing certain types of information. And because of that, I've developed this training to make sure that chapters get access to these legal requirements and to put chapters on notice that you should be following Navajo Nation laws and policies. And unless a chapter has like thousands of dollars to pay out to an individual who's harmed from releasing information, then so that's the reason why I'm writing the training.
Where could I find the Privacy Act?
Of course. You can find the Privacy Act on, and I thank you for asking that question. In this PowerPoint, I'll definitely put a section in here for resources. You can find the Privacy Act at 2 NNC Section 81.
81, okay.
And then you can, yes, ma'am. And then you can also access the resolution CAP. So CAP, C as in cat, A as in apple, P as in Paul, hyphen the number 4, the number 8, hyphen the number 9, the number 9. And that was the original resolution that was passed that amended Title II.
There hasn't been any amendments since then?
So there has not been any amendments to the Privacy Act. However, so the reason I also talked about the Supreme Court case is because the Supreme Court in S as in Sam, C as in cat, hyphen C as in cat, V as in Victor, hyphen the number 2, hyphen 06. Also clarified a couple of things regarding the Privacy Act. So that's also good law, which is in 2006. So generally what happens is after the Navajo Nation Council has put a law into place, if there are any lawsuits or any cases that were pending in front of the court, they will usually come, like, so if someone was saying that there was private information that was used or disclosed, they'll file a lawsuit, and then in the lawsuit, especially here in the Navajo Nation Supreme Court case, it will clarify information and will provide additional information, which may affect how the original statute and the plain reading of the statute is read. So as far as an actual council amendment, there has not been an amendment, but there has been a Supreme Court interpretation which takes that statute under Title II and then clarifies it, and wherever there's those modifications, that becomes the law.
Okay.
Does that make sense?
Mm-hmm. Thank you.
Okay, you're welcome. And there is also an attorney, an opinion from the Attorney General in 2008, which also explains the Privacy Act. And that was released in 2008. So, which is why I talked about the three documents, and the 2008 opinion by the AG also is the interpretation and further clarification of what the Privacy Act law means and how it applies.
Okay, and then if I want a copy of the opinion, where may I obtain one?
I will definitely ask where I can get this opinion to you. If you send me an email, I'm not sure which chapter you're calling from, but if you send me an email asking for the AG opinion, just send it to me by email and I will respond accordingly.
Okay, an email. Okay. Okay, I'm calling from the Bird Springs chapter.
Okay. All right. Okay, so I'm going to move on to the next topic. Is everyone okay with that? Do you have any more questions?
Naomi,
Yes, sir.
this is the chapter coordinator. This is Tyson Ramon for Church Rock chapter.
Yes.
Could you go ahead and send me through the chapter emails what the I believe I didn't catch that chapter what she was from, but what she's requesting. If you can also include me with what she had requested, because right now I know I transferred from, I just started here a little over a month ago, and right now there's a lot of things what's going on with the Privacy Act here. So there's a lot of things that I'm clarifying with my officials and the current AMS. So there was a lot of, it just wasn't being run properly. So everything I'm trying to code with them, and these Privacy Acts, what you had just went through your slides and everything.
Yes, sir.
It was beneficial for me on my end, trying that way I can use it and I can interpret it, this is, how things should go. There's laws that were passed already. So I'm just referring back to, because, when I worked with the scholarship, I used FERPA, the release of confidential information unless we had a consent form. So that's how I'm doing it here now. Until I get consent from the individual to release information, that's how I'm releasing it, unless I have it on file, and then I can go ahead and do that. But, if they want to be, they want something done, they want information released, I just have to get a release of consent for confidential information. But it's not like social security numbers or anything, more like pictures, if they want to be like that. I just have, that's just how I'm doing it now here at Church Rock, because there's a lot of things, and I don't know, who had sued the nation on all of this stuff, but that I just don't want that to happen anytime soon while I'm here at this chapter.
Of course. And Tyson, if you would send me an email also, as I asked the kind lady who asked about the question from Bird Springs chapter, just send me an email and I will respond again accordingly. If you have a form, so the form that you use and the policy that you currently have in place, if you want to send that over to me, I can look at it to see whether or not it complies with the information that I have, and I will also see about getting you copies of Title II, the council resolution, or the council resolution that implemented and amended Title II. I can send you all that information by email.
Okay, yeah, that'll be fine. I'll just go ahead and email you then at ingilmore@nndoj.org.
Yes, sir.
Okay, all right, I'll go ahead and do that.
Okay.
Thank
If there are no more questions, I'm going to move on to conducting meetings. And here I want to make some clarifications. As this is important information because I'm going to send out an all-chapter memo regarding planning meetings. Okay. Is there any more questions? Okay, moving on. see, I thought I opened it up already. So file. Okay, the next training is on Title 26, conducting chapter meetings. And I've provided this training before, and I'm going to give this reading again. This presentation is intended for general information purposes only and should not be considered legal advice or opinion on any specific facts or circumstance. The reason I do that is because I don't have specific facts for your situation. However, at these DOJ virtual training meetings, the reason I provide that disclaimer is because each of the chapters that I represent, there's 110 chapters that I provide legal services to, including DCD. And so when I provide legal services to you all, my duty as a legal counsel to chapters is to make sure that any information that you share with me is confidential. So I'm going to ask that if you have a specific question about your chapter regarding this topic, I would ask that you email me what's going on at your chapter, so that way the confidence of so the information that you provide to me is kept confidential. And so just in the future, if you're asking me questions, please state them very generally, but not giving specific information as to what's going on in your chapter, because that would be a different forum. And as an attorney, I would need to make sure that your legal, any information that you share with me is protected. Okay, Section 1002, meeting and notice requirements, compensation of chapter officials. So chapters determine the number of meetings to be held, and chapter president has a right to call a special or emergency meeting. This PowerPoint presentation is going to be a little bit different from what I provided earlier, only because I'm going to ask you all to actively engage with me. I'm going to ask you a couple of questions. So I'm going to provide a brief synopsis of what the law is, and then I'm going to ask you to apply it. So this will help you understand what is required. So notice requirement. Chapter officials shall post all chapter meeting agendas within the chapter boundaries at least 48 hours prior to the meeting. And that's a requirement under Title 26. Chapter official means chapter president, chapter vice president, and a chapter secretary treasurer. Now, the question sometimes whether or not a grazing official is a chapter president or whether or not a council delegate is a chapter official. Within Title 26 is very specific that chapter official means chapter president, chapter vice president, and chapter secretary treasurer. However, the officials should be able to work with the grazing official and the council delegate on certain matters. And however, for the requirements of Title 26, chapter official does mean president, vice president, and chapter secretary treasurer. Posting the agenda is a responsibility of the chapter officials. This is not delegable under Title 26. What does this mean? This means that if a chapter official, so the chapter officials, the president, vice president, and chapter secretary treasurer should be posting their agenda for their planning and regular meeting. They should be meeting together to make sure that they post the agenda for their meetings. And this is not delegable under Title 26. And 48 hours is calculated from the time the agenda is posted. And the chapter boundaries may be on the front door of the chapter house, in the bulletin board of the chapter where notices are placed, and can be broadcasted. So the reason I put "and" is because the first requirement is definitely required, that it should be somewhere within the chapter boundaries on the chapter, in the front door of the chapter house, and the bulletin where community members are used to seeing notices, and can be broadcasted or announced on the local radio station which the community has access. and this requirement ensures that the community is aware of the chapter meetings. So one scenario. So the first scenario is the chapter administration. So I'm applying what we just went through. Tell me whether or not this is accurate or complies with Navajo Nation law or not. The chapter administration is asked to post the agenda.
Accurate.
So would that comply with Navajo Nation law?
I would think so, because it's a related task. You could ask for their assistance, because I think in Title 26 it does state that we can delegate some of these authorities to individuals within the chapter administration. But I think in order to ensure that the agenda is posted and people view the document, we may ask for their assistance.
Well, I didn't see that in Title 26, in a plain reading of Title 26, because as I stated earlier, the posting of the agenda is a responsibility of the chapter officials.
Okay.
And it's non-delegable, which means that you're not supposed to delegate to chapter administration task. And that's just a plain reading of Title 26. Okay. So the second one is elected officials. So tell me whether or not this complies with Navajo Nation law or not. Elected officials post the agenda on Facebook only.
No.
Okay, why do you say no?
Because it's not within your chapter boundary. I mean, not everybody is connected to the social media world. I mean, the kids, the older generation, the elders don't have Facebook, so how are they going to know these things? If their kids, well, relate, oh, there's a chapter meeting on this day, they're going to forget, but majority of the time, the elders and, if it's the membership, if they're the younger generation, then yeah, they'll pass the word along. But, the elders like to read, they would like to see something visual posted within their chapter compound or, where the postings are going to be done. So, that's just how it is. I mean, that's how my the members here, they like coming to the chapter and saying, okay, this, I like this now, this was never done before, everything like that. So that I have to instruct my host, but not all. On Facebook, it's good, but at the same time, bad at the same time, but just not only on Facebook. So everybody's not connected to the social media world. And so that's probably the only factor that I would have to say. But, I like to post on black and white around for, others to see.
Sure. And so the reason I say that is, so the first requirement, as you said, is accurate, that the agenda should be posted within chapter boundaries. Facebook may not be, it's on the internet, and Facebook only posting it there would not be in compliance with Navajo Nation laws and policy. But if what happened is the elected officials post the agenda on the chapter boundaries and Facebook, then I think it'll be okay. However, I think that would be okay, or any type of social media to get access, so really it's a notice requirement, making sure that the community knows when these chapter meetings are taking place. Next question. The agenda gets posted the day before the chapter regular meeting. Would that comply with Navajo Nation law?
No.
No.
It's supposed to be 48 hours ahead.
Yeah. And when does that time start to calculate?
Before the
48
chapter
hours
meeting.
What's that?
They post the meeting.
Especially from the
8 hours before the time of
48
the
hours.
meeting starts.
So that's
So
kind of
if
one of
our
those
meeting-
things where I think it's one of those areas where it's from the time. So it starts the clock runs from the time the agenda is posted. So for example, if there was a chapter meeting at 12 p.m. on Sunday, then the chapter official should at least post the agenda by Friday at noon. But if they post it Friday at 1 o'clock, then it wouldn't be 48 hours because they're having their chapter meeting at 1 o'clock. And it's, I know it's an hour, and some people think, oh, well, what's the big difference? Title 26 says it's 48 hours. So then, so it's important that these agendas get posted 48 hours before the meeting.
I think it's just common sense that the individual posts their agenda on time to give the public enough notice.
And it's kind of it's one of those things too, like how do you track that and how would you calculate that? How do you know that a person is actually doing what they're supposed to do 48 hours before they're supposed to do it? So I would make sure that there's like a process in place where it must be done by, so post it more than 48 hours so that way you're always in compliance would be my suggestion. If you have a planning meeting.
Yeah.
Yeah.
Talking about processes, I know with Title 26, it is pretty vague, very general basically. When we're trying to talk about processes, would you think it'd be a good idea to develop bylaws for the officials to explain in detail processes and so forth, so that it's not just hearsay, but something is in writing to indicate that this is the process of posting an agenda or recording minutes or things like that?
I think that process is embedded in Title 26 already. So this information that I'm getting, it's all from Title 26. So all the information that I'm getting and providing to you is just a plain reading of Title 26. All the processes and procedures are already there.
Okay.
And so developing a bylaw, and I think there are sometimes there are areas where maybe, but it's a good suggestion. I'll definitely think about it, but I'm not quite sure if whether or not it would be a bylaw. It probably would be more of a frequently asked questions format because so the way that I see it is that bylaws are just additional procedures, but maybe doing a Q&A or frequently asked questions dialogue on these different topic areas, that may help because sometimes applying the law and actually what happens out in the chapter world is always different, and only individuals who are on the ground know exactly what situations come up. So I will look into working on a frequently asked question model, especially for conducting chapter meetings, and try to send it out within the next 2 months. I know it's it's probably not as a reasonable time frame, but counseling 110 chapters can sometimes be a little difficult. But I am working on making sure that all of your needs are met. Okay, so the next question. A community member volunteers to post the agenda on the chapter bulletin. Does that comply with Navajo Nation law?
No. No.
Why do you say no?
Because we just read that it is stated in the Title 26, it's the responsibility of the chapter official.
Yes.
That's like asking a community member to write a resolution for you while it's the responsibility of the administrator or the secretary treasurer.
That's accurate.
Because it's a legal document.
Yes. And how do we hold individuals accountable for these things? Well, so if there are
Please
things that are being,
tell me.
what's that?
Please do share. How do we hold people accountable?
Well,
when they took the oath, they did say they're going to comply with the laws and the policies and procedures of the Navajo Nation.
Yes, ma'am. So yes, they do take an oath, and their oath does say that chapter officials will comply with all Navajo Nation laws and policies, and uphold the laws of the Navajo Nation government, as well as the Treaty of 1868. So that's the oath that they take. And also, if chapter officials are acting in non-compliance with their duties and responsibilities, you can certainly send a complaint to ERO. But also, if really what the problem is that maybe some chapter officials or other individuals don't quite understand what their roles and duties are, you can also contact DOJ to see if whether or not there could be training provided, provide some guidance as to what those responsibilities are supposed to be. But I think what I'm going to do is try to work on that frequently asked questions template as much as possible, and then send it out to all of the chapter officials. So that way it'll give them an opportunity to review some of those areas that seem to be a little bit gray. And so I can definitely do that first before all of those other things. So it kind of depends. It's kind of a case-by-case scenario. And to hold people accountable, ERO handles any ethical rules, and so any ethical violations. And not complying with Navajo Nation laws and policy would be an ethical violation. However, there are different circumstances where some of those ethical violations can also be considered have criminal penalties and would be sent to the prosecutor's office. So it just really depends on what's going on and the facts and circumstances of the chapter. Okay, moving on.
Okay.
The order of business, section 103. The chapter president shall chair all regular or special meetings. The chapter president shall call emergency or chapter meetings. And if the chapter president is absent, vice president can chair. And also the other option is that the chapter membership present at the meeting that meets quorum may select a chairperson pro tempore for that meeting only. So here is this another scenario. Who can call a special meeting?
Chapter president.
Oh yeah, sorry. I think I wrote it down already. Sorry.
Oh, sorry. You get to get some of those.
Okay. Who else?
That was a trick question.
Who else can call a chapter? Call a special meeting?
The public.
The Title 26 is not clear on that, but I don't think so.
Okay.
They also depend. The reason I say it depends is because there are chapters who may not have any officials. Could happen. So I think in that case, it would just be a different scenario, and that would be, we'd have to analyze the facts to see whether or not that would be okay. Who else can call a special meeting?
So would the chapter vice president have authority to call a chapter meeting if the vacancy's there for the president's position? But say, Naomi, say you were VP for a chapter, but the vacancy of that president left, but you did not want to assume their responsibility of the president position. So then there's, we can hire a pro tempore for that special meeting only, but at the same time, then we have to go through the election process and everything like that in order to fill that vacancy. Would that be one way or no?
Well, that's so
Scenario.
yes, that is a but I think one, the vice president automatically under Title 26, the vice president automatically assumes the duties of the president in his absence. So whether or not a vice president doesn't want to take on that responsibility, it's automatic. So in the interim, when you're working with the elections office to hire a new chapter president, the vice president is really the responsible person to make sure that they chair the meetings. And the only way that if, for example, so I think that's one of those areas. But hiring a chair president pro tempore, I haven't heard of that scenario, but the other situation could be that only if the president and the vice president are both absent, then the chapter membership can elect a pro temp president to chair that only that one meeting. That's what Title 26 says.
I thought it was just a secretary treasurer.
What's that?
Because you can't have just one official officiating the chapter meeting.
So in Title 26, it does say that the secretary treasurer should also be able to help the president and the vice president. But the best scenario would really be if both the president and the vice president are unavailable, then my recommendation would be to hire have the chapter community elect a chairperson pro tempore for that meeting only, and then allow the secretary treasurer to continue to do the things that she needs to do or he needs to do, which is taking notes, making sure that the chapter planning meeting is being recorded. That's also one thing I want to talk about too. If your chapter is currently not recording your chapter meetings, I am going to be sending out a memo maybe within the next couple of weeks, asking chapters to make sure that they're implementing, they're making sure that the chapter secretary treasurer is recording the chapter meetings, planning, regular, special, emergency, like all of them, and then asking if whether or not the administration can then put it into a centralized, digitized database, so that way I have records to that. And so I'm also going to provide some information on who can have access to those records. So the reason I'm talking about this is because sometimes there are things that happen at chapter meetings and other people are complaining that chapters are not following Navajo Nation laws and policies, or they're doing things inaccurately. So that recording will allow me to review it and then figure out whether or not something did or did not happen in compliance with Navajo Nation laws and policies. And that also would be, sometimes in chapter meetings, and when people are complaining and the outside are complaining about certain things, then it helps me understand what really happened. And so I'm going to ask chapters to purchase a tape recorder. I think the title states that it should be a tape recording device, but I think times have changed and there's more technology, so I think we can definitely, there's different recording devices like
Digital recorders.
Yeah, digital recorders, and then putting those digitized recordings in a folder to allow the chapter officials, the council delegate, DOJ, and if your chapter has your own attorney, granted that you followed the proper procedures to have your own attorney, those are the only individuals that it would ask to have records and access to that information. So, I will be working on that also. So make sure that your secretary treasurer is reporting those meetings. Okay, so then we already talked about in the absence of the chapter president and then chapter vice president. Okay, so here's another scenario. Determine if the following comply with the LTA. The chapter secretary is the only elected official at the chapter, and he or she calls a special meeting. Okay, we already talked about that. The chapter vice president, on his own initiative, decides to call a special meeting. Does that comply with Navajo Nation law? His or her.
The chapter vice president?
Yeah, the chapter vice president, on his or her own initiative, decides to call a special meeting.
No, I don't think so, unless unless he or she was in an acting capacity, not based on a need within the community, or something that needs to be addressed immediately.
So is it in need of the chapter, or is it in the absence of the chapter president?
Well, it would be in the absence of a chapter president, based on the need of the chapter.
Yes, ma'am. So, but the statement, the way that it's written, is that the chapter president or the chapter vice president is saying, "Oh, I'm going to call a special meeting," without, we don't know whether or not only if the chapter president was not available, then I think that the vice president can. But without that, the chapter president usually has kind of sole authority to do that if he's available and he's present. Okay. Section 1003B, quorum requirements. All chapter meetings require a quorum of 25 registered chapter members to conduct official chapter business. Chapters, whether governance certified or not, may amend the quorum requirement based on models and procedural regulations adopted by the Resources and Development Committee of the Navajo Nation Council. Adoption of an amendment quorum requires approval by the chapter ballot measure in accordance with the election code. So I'm going to provide some clarification here. So I ask that you pay attention to the clarifications, and I'm also going to be sending out a DOJ memo on it, an all-chapter DOJ memo regarding this clarification. So in Title 26, it states that all chapter meetings require a quorum of 25 registered chapter members to conduct official chapter business. So the reason that I have chapter meetings, registered chapter members, and official chapter business put in bold is because I'm going to explain them a little bit further below. So chapter meetings include regular and special meetings. Planning meeting does not require a quorum so long as a chapter does not conduct official chapter business. Official chapter business means acting or not acting on an action item on an agenda. Chapter membership means for voting and participation in chapter government, all registered voters. And for the benefit and services, all tribal members, young and old, who reside or are registered in the chapter, an individual may or not, may be a member of more than one chapter. And lower quorum is subject to approval through the proper processes. So when Title II was amended, the reason I have an asterisk under Resources and Development Committee is because when Title II was amended, NABI in I think 2 NNC 701 stated that any references to TC, DC, or economic development shall mean Resources and Development Committee. So anywhere where it says, so if you're looking at the Navajo Nation Code and there's a reference to transportation and community development and also the economic development committee. What now you're going to look at is the resource development committee now has that authority because of the Title II amendments back. I don't remember when Title II was amended, but you can find Title II amendments under 2 NNC 701. So the clarifications here with regard to quorum requirement is that in a previous DOJ memo, it was stated that a planning meeting was a chapter meeting. And so because it was a chapter meeting, because the title here, there was an interpretation that all chapter meetings require a quorum of 25 registered voters. All chapter meetings means planning, regular, special, and emergency meetings. But because so the basis for the interpretation, so all of the previous DOJ memo that stated that a planning meeting requires a quorum is no longer, is going to be trumped. And so going forward, the only chapter meetings that require quorum will be regular and special meetings. So even though Title 26 does say that all chapter meetings require a quorum of 25 registered chapter members to conduct official chapter business, the thing about that is that if a planning meeting, at a planning meeting, from what I understand, if chapters are not conducting official chapter business, then there's no quorum requirement. So it's kind of like a layered analysis. And what that means is that most planning meetings, the only thing that the intent of a planning meeting is for the chapter officials to get together to plan for the regular meeting. If that's all that's happening, they're putting together the agenda, putting everything into, you know, how they're going to talk about things, they're organizing, they're planning to have the regular meeting, then they're not taking official they're not conducting official chapter business. Conducting official chapter business means taking action on an action item. For example, at a regular meeting, the chapter membership is asked to vote on certain things. So that really would be the official chapter business within the meeting of Title 26, which is why one person can interpret all chapter meetings to include all of the chapter meetings. However, the second layer of that is that to conduct official chapter business. From what I understand, most chapters only at a planning meeting will talk about and discuss what they're going to talk about at the regular meeting. So if that's the case, then there's no quorum requirement. And in addition, the quorum of 25 registered voters is a requirement because under chapter membership, the registered voters should be registered with that chapter. But if the chapter properly lowered your quorum through submitting your changes through RDC and you went through the proper process and you have a lower quorum, like I think there are some chapters who have a lower quorum of like 13 and some at 17, kind of depending on the basis and the requirements listed in Title 26. So that's a major clarification that going forward, planning meetings do not require a quorum so long as a chapter does not conduct official chapter business. Okay, that's a major clarification there. Okay, and here's a couple of scenarios. The chapter president calls to order a regular meeting when 25 individuals, some registered and some not registered, show up at the regular meeting. Does that comply with abolition law?
That's gonna come up on 30 on. Did you take George Jones Road off?
Does that comply with abolition law?
No, because it all depends how many are registered and how many are not registered, because it has happened in our neighboring chapter. They didn't have enough registered members, but they counted the youth students under 18 to make a quorum.
Mm-hmm. then any action items that took place, any resolutions that were passed, and anything that happened at that meeting is invalid.
Okay.
So would it be appropriate to ask before the meeting begins who is a registered voter?
So one of the things I recommended to chapter officials is asking the elections office to provide the registered voters of the chapter, and making sure that the chapter has a list. And you can contact, I think, Albert Little, I think is his name, from Navajo Nation Elections Office. You can contact him and ask if you can have, the chapter can have a copy of all registered voters of your chapter. And then when you get your sign-in sheet, you can reference who is you can reference whether or not their person is a registered voter or not. But I think it's also a good idea, from what you're saying, who is a registered voter, so you can verify at the meeting whether or not you have enough registered voters.
Excuse me, Leslie. I have our former Secretary Treasurer that wants to put his input in, Alberto Pashkai. Hold on.
Hello, Leslie.
Oh, this is Naomi Gilmore.
Oh, Naomi.
Oh.
You have Leslie on here.
Yeah, that's just the account purposes.
Yeah, it's the account. So my name is Naomi Gilmore from DOJ, and I'm legal counsel for all chapters.
Okay, I just have just a point of clarification in regards to your statement about the voter registration. One of the things that we came across was, well, when I was a chapter secretary treasurer, we would all basically already know who's a registered voter and who's not. But in order to provide, to actually verify that individuals are registered, I had to become a voter registrar with the Fort Defiance Election Office, to where I was able to be given a listing of all our active voters and those that have been purged. But as far as asking for a listing, if you're just a regular chapter officer or either an administrator of a chapter, they will not release that listing because of the Navajo Nation Privacy Act, because it has names and census numbers that are associated with the voter registration name. And that's how they provide the listing to the registrars, is they have the listing of name, and then they have the status if they're active or non-active, and then followed by their census number. And so, but my recommendation would be that if the chapters, when they have their meeting, it would probably be best if the chapter secretary treasurer become a voter registrar, to where they have access to that information, to where they can verify that, because that's what we had to do. That's what I did during all my chapter meetings for the last 8 years, is make sure that these individuals were registered when we took action on anything like that.
Do you know whether or not that process is, hard, or what you have to fill out?
What they would have to do is basically just contact the election administration. The one that I work with, that I work well with, is Veronica Curley, and she would be the one to basically have to give you a listing of where these trainings will take place, because they have trainings throughout the Navajo Nation. So she would be the one to contact, because she works closely with the actual election administration. That's just one door down from their office. And so they can come together and then basically put that together. Because that's one of the things that we were hoping that they would do at their chapter officials orientation, as far as quorum requirements, is that they at least have one of the chapter officers, but it'd probably be best that the chapter secretary treasurer, because they're the actual one that does the roll call and takes the minutes of the meetings, that would be a voter registrar, to where they have access to the listing of names of the community, of their constituents that are registered.
Okay. One of the other things I think I'm going to do is look into whether or not the Privacy Act actually does apply. So although there is a census number, I'm thinking that for the purposes of, well, I'll look into some of that. And so I understand that the voter registration has census numbers. So I'll look into that to see if whether or not there's like an easier process to allow chapter officials, for legitimate government purposes, to be able to access this information a different way, and not have to have everyone become a registered
Voter.
What did you say, to be a,
Voter registrar?
yeah, to be a voter registrar, to see if there's a way that it can be accessed a little bit more efficiently. So I'll look into that. But thank you for your recommendation, though, about the Secretary Treasurer becoming a registrar. I'll look at the benefits and the disadvantages and advantages, and then provide scenarios and how we can try to figure out how chapters can make sure that they meet their quorum requirement by making sure that people are present at those meetings. So thank you for that, sir.
Yep. And then I just have one question based on what you said, that if a neighboring what Sherry posed as neighboring chapters utilizing underage individuals to make a quorum, but that would also be invalid if these neighboring chapters use individuals that are with outside organizations from the Navajo Nation that are there to give a report. I've seen a lot of our chapters within Southwest Navajo, they count these individuals. I know, I mean, when I visit a chapter, they count me as part of their quorum as a person abstaining, and I don't think that's correct. In order for
it isn't. It wouldn't be correct. Unless you're a registered voter of that chapter, you should not be counted as counted to meet that quorum requirement. And only if you're a registered voter, you should be counted. And even with those resolutions, so I'll talk a little bit more about that too. Even with resolutions, you should be able to have quorum also.
Yeah. Okay.
Okay.
All right.
So
I just
okay.
Naomi, this is may I ask a question? This is Verna Yazzie with Birch Springs chapter, and this is back to, I just want clarification. This is back to Alberto's comment about him attending chapter meetings and he's being counted in the chapter count. So if an individual is not registered with the chapter and they're representing a department or program and they show up, we cannot count them as to be abstaining from the meeting?
Nope. So the reason
they're not even.
Yeah.
Go ahead.
So the reason for that, let me go back up to, so if you go to Title 26, under Title 26, chapter membership means for voting and participation in chapter government. It's very specific to who is going to be counted as voting. So voting and participation in the chapter government, which is where you get like your quorum, your votes for certain things, those are all registered voters. However, if it's for benefits and services, then it's of course all tribal members. So there's a distinction in Title 26 that talks about who can vote.
Okay.
And
Thank you.
Individuals who come to the chapter and they're there just participating. Yeah, it's which is why it's very important to make sure that you distinguish between the two. And one other thing that I'm thinking about too, just like if I were the chapter house, maybe what you all can do is provide two different, like, you know, and I don't know whether or not this would be accurate, but I guess kind of one way to calculate is if whether or not the chapter kind of organized the chapter meeting to allow all the registered voters to sit on one side of the chapter, and then all the non-registered voters to sit on the other side. That may be able to help you kind of, you know, decipher who is not a voter and who isn't. Because I can see the situation that it can be a little bit hard in practice, right? Because you're at the chapter house and you have everybody scattered everywhere, and people are, you know, putting up their hands, abstaining, voting, and you don't even know whether or not everybody there is properly voting or properly voting. And if they're there on another, and whether or not these individuals even know whether or not they can or should be voting. Does that make sense?
Yes, thank you.
So I'm thinking that maybe, and I mean, just as a practical matter, in practice, that maybe that could be one way to handle it, that, you know, you put all of your put all of your registered voters on one side, and then just explain at the beginning of the meeting the reason why you're doing it. And then all the individuals who are presenting or all the individuals who are there just in attendance to get information, they sit on another side. So that way it keeps the chapter just by a visual who's voting and who's not voting. Does that make sense?
Yep, thank you.
So, but then of course there may be some because you know, people think about things differently, and they may say, well, why are we dividing people, and why are we having people sit on one side? And just because they're a registered voter doesn't mean that they're, you know, whatever people will come up with. Of course, I'm just saying that that's maybe one way. It's not the greatest, but it's an idea, and maybe there are other things that you all do that provides better basis for implementing the 25 quorum requirement. Do you have any suggestions? You all are on the ground putting the laws into place, doing the practice of or you're actually carrying these laws out. Okay, so let's move on to the next scenario. 10 non-registered voters and 16 registered voters show up for the chapter regular meeting. Compliance or not in compliance?
Not in compliance?
Yes. So I'm going to say not in compliance. Yeah, I don't even think I have any.
No, it would be.
Well, unless there's a lower quorum of 13, but I was looking at 25, yeah. I was looking at 25 quorum requirements when I wrote this, so make it a little bit more. A chapter resolution is passed showing 20 for, 6 against, and 1 abstention for a 25 quorum requirement. Is that valid?
No.
Yeah.
Oh, I guess it depends on who's all there, if they're all registered.
If they're still in that scenario.
Yeah.
See.
Because if they're not all regular registered chapter members, then it's not going to be valid.
Yeah. So it kind of, yeah, and it depends for this. Yeah, it definitely depends. Because if you have like 20 individuals who are all registered and you have 5 of the individuals who are against were registered, then you may have, it may be valid. But if the situation is that there's 20, maybe there's 15 individuals that were registered and everybody else is not, it wouldn't be valid.
No, 20.
So it just kind of depends on who's all there and who's present and whether or not they're a registered voter or not. All right, moving on, adopting standard rules. Do you have a question, ma'am?
No, I'm fine.
Okay. Adopting standard rules. Chapters may adopt standard rules for conducting chapter meetings, and that's under 1003C. Approved by chapter membership and through resolution, meet quorum requirements and recorded documents by official administration. Standard procedures must also comply with 26, 1002, and 1003 requirements. What that means is that ordinarily all of the rules and procedures for conducting chapter meetings comes from Title 26. However, if the chapter by a resolution wanted to change that and adopt, you know, maybe Robert Rules of Order or a different type of way of conducting chapter meetings, then it should be approved by the chapter through a written resolution that meets quorum requirements, and it's recorded and documented by the officials and the administration. And then you can implement that, the standard rules of order. But if that's not done and the chapter officials are using Robert Rules of Order when there is no resolution, no approval by the chapter that meets that quorum requirement, then it would be invalid, and the chapter would be conducting their meetings out of order. So under Title 26 rules on motions, so I'm not going to get into detail about this. I'm not going to talk specifically in detail about rules on motions because Title 26 is very specific. And if you do a plain reading of it, you'll understand that the agenda, reports, minutes, and everything should be presented in front of the chapter membership. And then the chapter president at that time, after everything's kind of at the beginning of the meeting, the chapter president shall request a motion for the chapter member to accept all the items and recognize a second on the main motion. So, and then afterwards, the chapter president, after a motion and second to the provide an opportunity to members of the chapter to address the matter before the chapter membership. What this means is that after everything, so the agenda and everything is approved, then the chapter president will say, okay, moving forward, chapter membership, do you have any issues with what we're talking about or whatnot? And that's when all of the chapter member can make amendments to the agenda or substituting motions and all of those other things take place. And this is really talking about all of those things I just explained a while ago, proposed amendments by the chapter membership. So any member may propose an amendment to the main motion. If this happens, then the membership shall vote on the proposed amendment motion. If passed, it shall take precedence over the part of the main motion subject to a proposed amendment. Only one motion to amend the main motion shall be on the floor. Any member of the chapter may propose a substitute motion, and if it passes, it shall take the place of the main motion. The substitute motion shall be seconded and voted on. And any member of the chapter may propose to table the legislation or issue before the chapter. The motion to the table the matter should be seconded and voted on. If tabling motion passes, it shall take precedence over other motions. The chapter president, vice president, secretary, treasurer at a duly called chapter meeting are prohibited from making main motions and second motions on substantive and administrative matters. They may make motions and seconds during a planning meeting, except the chapter president can break a tie under Title 26. So here's a couple of scenarios. The chapter president does not allow a chapter member to propose a substitute motion. Does that comply or not comply with Navajo law?
No.
Why not? You're right, but can you tell me why?
The president does not allow chapter member to propose a substitute motion. It depends on the action item.
Don't we always do?
Can you?
Can you elaborate on that again?
Yeah.
Yes, I can do that. So the chapter president does not allow a chapter member to propose a substitute motion. So earlier when I was talking about the proposed amendment, so if you read at the top, it says any member may propose an amendment to the main motion. So, but here, the chapter president does not allow a chapter member to propose a substitute motion.
So basically, substitute and amendment is just two different words, but the president prohibiting that member from not doing that basically is incorrect action by the president, I would assume.
That's correct. So the reason it's incorrect is because the chapter president must provide an equal opportunity to all chapter members to talk about certain things, like what issues they have. So if there's a chapter president who's not allowing an equal opportunity for an individual who is a community member to talk on certain things that's being provided, then chapter president is in non-compliance with Navajo Nation laws. because there's a requirement that the chapter member should be allowed to have that equal opportunity to speak.
So what is considered equal opportunity? If maybe they spoke once, do we allow them to speak a second time or a third time and extend their speech to 10 to 15 minutes? What is equal opportunity?
So that's a good question. And I think it would be a case-by-case scenario. The reason I say that is because a couple of things are a little, it's triggered. So you may have a community member who's very hostile and is just trying to anger people. In that case, I would say that maybe asking the community member to refrain from, speaking the way that they're speaking, or refrain from making things like very hostile in that manner. But also, if the community member is like taking a long time to talk about something, I would ask that, maybe kind of give some guidance and asking the individual to provide, whatever issues that they have in a timely fashion, because there are things on the agenda that needs to be taken care of. So on the one hand, it kind of depends. If it's like on a matter like that's very complex, then it's kind of expected that a person should be able to talk a little bit longer, as opposed to something that's not complex. And equal opportunity just means that, yes, okay, we've heard what you have had to say, and then I think that would be sufficient. But like I said, it really depends on the nature and the facts and circumstances of what's going on. But the chapter president should not just say, no, you're not going to talk.
And I have another question I'd like to propose concerning this scenario. Even though if it may not be the chapter president, but what if a registered member within there basically makes a motion to cease debate? Is that an acceptable terminology or use to or utilize within the chapter meeting?
Using debate, I think it would be proper if they were tabling a legislation. But to cease debate,
I mean, because let me give you in a scenario. We had several meetings last year. There were several hot topics that the community administration wanted to address, but there's several community members. When this item would come up for discussion, there would be individual clans that would be pro and then some that would be against. And when the president would like everyone to comment on that, then the certain individuals would say motion to cease and debate, automatically get a second, and then they would go to a vote. And that basically prevents the president from recognizing other members to speak, and then they call for a vote just to rush through that item. Isn't that like sort of illegal in a way, or not correct?
I would say that on a legislation or on a specific legislation or resolution, all members should be able to have the ability to speak. So, for example, if they kind of cease debate, that would be, so it kind of really depends on at what point, because everyone's supposed to be given an opportunity to speak on behalf of that legislation, to allow the community members to properly make a decision. So if one group is preventing another group from speaking on anything and they're not really getting their side, then that wouldn't be accurate, and it wouldn't be proper it wouldn't be guiding policy in a proper way, because it's like you're only favoring one group as opposed to another group, and that would not be accurate.
Okay, thank you.
Second scenario, elected officials do not allow a chapter member to speak on an issue. So this is kind of what we talked about. So that would be inaccurate. So that would not be in compliance with nomination laws and policy. Elected officials prevent a chapter membership to speak to keep the peace at the chapter meeting. Talk a little bit about that. I think this would have to depend on the hostility. So even if the chapter, even if there is like hostility there, I would suggest that the chapter officials use their other responsibilities and duties and postpone the chapter meeting. If things are getting too heated and everybody's like, you know, getting so angry and there's disorder at the meeting, the chapter president can postpone the meeting and adjourn and say, you know what, we're not going to talk about this now. Let's table it and then we'll talk about it at a future meeting. But even if the chapter president postpones that meeting, then he must also, during that same time, suggest when the next meeting should take place and should be able to do it at that time, because that way everyone has notice of when the next meeting is. And then also follow the next process, 48 hours before the meeting, make sure it's posted within chapter boundaries, and then continue that meeting. So you continue that same meeting that was started and just continue it. So you continue where you left off. You don't start a whole new meeting. And chapter officials are not paid for the next, so a separate regular meeting. It should be a continued meeting. Does that make sense?
Mm-hmm.
Okay. A chapter member proposes an amendment to the main motion. No other chapter member seconds the motion. Is that in compliance with nomination law?
Yes, no.
What was it?
A chapter member proposes an amendment to the main motion. No other chapter member seconds the motion.
Then the second, the amendment dies.
So in this scenario, does this comply with nomination law?
Oh,
Yes, no.
Didn't you say it was no? In the prior discussion?
Actually, this is really about making sure that anytime there's amendment to a main motion, you also have to have a second. So where it says no other chapter member seconds motion, so that would be, wouldn't comply if that only one motion was made and it wasn't second. That's really what I was getting at.
Okay. I have a question. So when a motion is made on a resolution, there's a title, okay, to fix a road. Let's say to grade the road, okay. So that's the motion or the resolution, and then the motion is to approve that resolution. Well, then the discussion happens, and then somebody says, okay, we just don't want it graded. We want the road to be improved, which is additional work, which is different from the grading. So is that considered an amendment to the main motion, or is that just an amendment to the resolution?
What does the member say?
So that's what I'm asking. They're saying, okay, the resolution says that the road will be graded. So that's the original resolution that the people made a motion on. Then they go into discussion. So during the discussion, somebody says, well, we want to make an amendment to the resolution to say we want road improvements rather than grading. So that's a whole different process for improvement. It's like doing a complete road construction, somewhat a complete road construction. So that's the difference between the two. So if a community member proposes that amendment to the resolution, would it be an amendment to a motion, or is it just to the resolution?
It would be an amendment to, if they said that, then of course you'd have to go back through and say, okay, do we, you have to make your motion, and then you second, and then you bring it before the chapter membership to see if whether or not the chapter membership agrees. So, but then also, it's also the job of the chapter officials to provide information as to what the difference is, grading as opposed to improvement. And then you have to provide, and you have to let the members know, okay, if this is what you're trying to do, did you know that grading is going to cost less because we have a backhoe here, or this is how much it's going to cost. To actually improve the road, here's how much a chapter has within its budget. We don't have enough money to do what you're asking us to do. But also, what you're asking us to do is also sometimes, with regard to some of the funding that you have, so it all depends on that and what the priorities are. So you have to go into more detail, the chapter officials have to go into more detail explaining what they're wanting to do. But also, just because the chapter membership wants to do a certain item, you also have to comply with Navajo Nation laws and policies. So just because there's a resolution out there that says that, the chapter membership approves something, you should also try to make sure that you're complying with everything else within Navajo Nation law.
Okay.
Does that make sense to you?
Mm-hmm.
Okay. So I think going forward, that probably would be the best scenario. And then maybe the chapter president can say, well, we can table this resolution until we get more information and see how we can try to proceed. We can table it for the next regular meeting. And we're not going to decide on that issue right now because we need additional information for X, Y, and Z. Do we have the money? Do we have, certain information? And because you may not have all that information, right? As you stated, you needed a grading is different from an improvement. So you're gonna have to go through and maybe contact CPMD. You're supposed to contact, vendors, procurement. There's all this other extra stuff that you need to do that you weren't prepared for. And to provide the additional information to the chapter members and let them know, well, since this is what you want and this is this decision, we're going to have to get more information for you and then re-present it again at another meeting and see if whether or not it's allowed. That would be the best way to resolve that. Okay. Postponing chapter meetings, we already talked about this a little bit earlier, that the chapter meeting can be postponed for lack of quorum, disorder at the meeting, unforeseen emergency. But when it's postponed, then the chapter shall provide notice to chapter members at the time and place of the next or continued chapter meeting. Compensation. You can look at the compensation. So no chapter official shall be compensated for a chapter meeting unless he or she was an official attendance at that meeting. The budget instruction manual says official attendance means present from beginning to the end of the meeting. You can also look at Navajo Nation, the budget instruction manual under Appendix M to find out more information on how you make those payments. And also make sure that the officials are providing you all with the claim forms, so that way you know that those claim forms, you can ask the Secretary Treasurer at the end of the meeting to collect all of the claim forms and then provide it to the chapter membership. No, not chapter membership, the chapter administration.
I have a
chapter. Yeah.
Okay, back to what you were stating about chapter official compensation. I recall that we had to, in regards, we had a former chapter president who was late for a meeting, for a regular chapter meeting, and they demanded that they get compensated. And so I had to fight that, saying that she wasn't an official attendance because she only attended 17 minutes of a 2.5 hour chapter meeting. And so your department provided us a legal opinion in regards to compensation in that, but then also included, there was another issue that we came about was where the chapter president where it said in the previous slide that I was looking at, it said that due to a lack of, if there's a lack of quorum during the meeting, but there's action items that have already been conducted, and let's say in the new business there's 10 items and they've already acted upon 7 items, but 3 items remain, and they lose quorum, instead of continuing that meeting, we were instructed by the former LGSC office that if the chapter officials want to get compensated, the presiding chair at that meeting just has to adjourn the meeting for that purpose. And then, once that adjournment is done, the chapter meeting is closed, and those items they can be brought before the next planning meeting to be acted upon at the next chapter meeting, rather than continuing that meeting to get quorum again.
I guess that would be one way. That would be one way of handling it. But also, if you're adjourning for lack of quorum, it seems to me that if you're adjourning for a lack of quorum and then you have to either do that meeting over again and then continue it, then it would still be considered the same meeting under the title and the code. But in the situation that you're explaining also, that, if they lose quorum, they adjourn the meeting, so I think at that point, if there is a lack of quorum, then, so before that happens, I would think that, and I don't even know how the situation would end, that the chapter somehow needs to make sure that those 3 action items are properly motioned to get onto the next meeting.
Well, in our case, when we did the meeting minutes, the president will say, due to lack of quorum, the meeting is now adjourned and no further action will be taken. And then that's just notated the time that the president made that statement. That's good enough based on what LGSC told us. And then those meetings, then people would question about those remaining items, and then it will say, well, they're going to be on the planning meeting agenda under new business as where it was in this chapter meeting. And we'll do the whole round again just for those remaining items plus additional items for that month.
Interesting. Yeah, I think that would require.
Yeah, if you can provide Sherry your email, I'll provide her that memorandum and the Department of Justice's legal opinion in regards to where the chapter president or the presiding chair has to state that the meeting is now adjourned. If they say the meeting is postponed due to lack of quorum, then at that basically that statement is saying that the chapter meeting is postponed but not adjourned. So then they would have to continue at another meeting or another date to when they're going to have the quorum to finish it in order to get compensated. But if the presiding chair says the meeting is adjourned, then basically whatever actions that they took is sufficient enough for compensation.
Got it. Yeah, and I think that there is the 2 distinctions between postponement and adjournment. So if you can send that information to me, I'll look it over and see if whether or not there are any. I'll see when the opinion was written by DOJ, and then because as you know, now ASC is the new. So the LGSC office, the LGSC office is no longer in existence. So now they have DCD and ASC, which provides technical assistance to chapters, and so the structure is a little bit different. So some of the plan of operation has also changed. So, which is why I probably would need to look at the information that you have to see whether or not that's still accurate.
Okay, I have a question back to compensation. There's in this Title 26, it also states that you have to submit your meeting minutes by a certain time and all the documents. So now, in my prospective chapter, I asked for a copy of the meeting minutes, but it turned out that meeting minutes have not been turned in, but individuals, the officials were getting paid right after they finished a meeting without having any document supporting their payment.
That probably should not be happening, because I think Title 26, I don't have my code book up, but I remember it does say there is a requirement that the officials submit a claim form.
Okay, so if the claim form is submitted but no minutes are attached, may they still get paid or not?
No.
Is,
I think that's
may
going to
you
be, I'll look into that
Go
matter
ahead.
because I think on the one hand, it might be beneficial so the chapter secretary treasurer is the person who's supposed to submit that, right? So
Yes.
I think if other people did do their job, for example, if the president and the vice president did their job, there would be no reason why you would withhold their payment. But because the secretary treasurer is responsible for making sure that those meeting minutes get to the chapter administration. Right?
So they're the ones that also sign, they're the secondary signer of all checks too.
Yes.
So they shouldn't be signing anything if they're not going to comply.
And I'm thinking that with regard to that, I can see about trying to make a clarification on those specific questions regarding payment and compensation. So the next portion is probably why you all are concerned about making payments, which you should be, because Title 26 does place the fiduciary duty upon chapter administration. So the chapter administration, the chapter manager, for purposes of LGA certified chapters with an approved fund management system, but a CSE for non-LGA certified chapters. Chapter manager to me is the same thing under the code. The only difference is that the CSE is supervised by DCD and the CSE is also an Navajo Nation employee. Whereas the chapter manager is at a LGA certified chapter with an approved fund management system policy, and they're not a Navajo Nation employee. So, so the way that I'm using chapter manager here is also, I think I'm going to put CSE in the next, I'll update it to put chapter manager / CSE. So shall be the custodian of all official books, records, documents, other and funds of the chapter. So if, for example, the chapter administration is issuing checks and signing checks that are not in compliance with Navajo Nation laws and spending those funds, affiliate as a manager to safeguard these items as cost for removal and assessment of applicable penalties pursuant to Navajo Nation law. So, for example, that's probably why you're concerned, and that's why you're not wanting to release funds unless everything is complied within Title 26. I will look into that a little bit more and provide clarification at a different, maybe by memo. If you could send me, ma'am, you've asked me that question. If you can send me the question in email format, I'd appreciate it, and I'll respond appropriately.
Okay.
Okay.
Okay, and so this is the end of the PowerPoint, and I'm just going to read a disclaimer. The Navajo Nation Department of Justice provides the following disclaimer. This presentation is intended for general information purposes only and should not be considered legal advice or opinion on any specific facts or circumstances. The reason for the disclaimer is that while generally, in most cases, the information provided in this presentation will be applicable, in some situations, there may be facts that require different information. If you feel that a situation is unique or out of the ordinary, please contact DOJ for further assistance. Okay, so that's the end of the presentation. Thank you. You're welcome. If you have any other questions, you can email me, and have a great day. Hopefully the information I provided to you was helpful, and thank you for the work that you do for the chapters.
Have a good day, everybody.